Good morning, Council, and welcome to this morning's session of the Kansas Court of Appeals. We appreciate your flexibility today in meeting by Zoom. My name is Catherine Gardner. I'll be the presiding judge, and with me today is Judge Kim Schroeder and Judge Amy Klein. This case that's left is case number 122201, and it's set for 20 minutes. It's in the matter of the equalization appeals of the Kansas Star Casino LLC for the year 2018 in Sumner County, Kansas. Council may have your appearances, please.
May it please the court, David R. Cooper on behalf of the appellant Sumner County.
And if it pleases the court, Jared Kiefer, Stinson LLP on behalf of Kansas Star Casino, Abilene.
Thank you, Council. Mr. Cooper, you may begin, and please let me know if you'd like any rebuttal time.
Thank you, Judge. I'd like to reserve 5 minutes of the time for rebuttal. This is a 20-minute argument.
Very good.
We'll see if we can do something about not using it all. I'll open with the prayer that the county's asking for here. The county asks that the court reverse the decision of the Board of Tax Appeals, which disregards the legal requirements for gaming to occur on the subject property and the hypothetical sale and when determining fair market value of the real estate. For 2018, this is not the first time this issue has been before the court. For the 2018 appeal, there's one fundamental disagreement between the parties, and that's the amount of depreciation. It's also discussed in the briefs as functional obsolescence. And the problem's a basic one. It's a formula that's being applied using the cost approach, and the basic problem turns on a hypothetical within the hypothetical. And fundamentally, the Board of Tax Appeals and the Kansas Star gets the hypothetical wrong in this case, and it drastically undervalues the property. The overarching hypothetical that is the task, the statutory task, is to determine the fair market value for a hypothetical sale that occurs on January 1, 2018. And fair market value is a statutorily defined term. Well, the amount of money a well-informed seller would accept from a well-informed buyer for the subject property. The parties agree that the cost approach is the most reliable indication of market value for this particular property. And for 2018 valuation, Boda and Kansas Star posited a fair market value based on an assumption or a conclusion that the ancillary facilities for the Kansas Star gaming facility, which includes the arena, a conference center, and an equine facility, are functionally obsolete or are super adequate. And thus Boda elected to wholly depreciate the ancillary facilities. And it's the county's contention that this deviates from the use path and is unsupported by substantial competent evidence. A deviation from use path is an error of law that must be corrected. And it also deviates from the constitutional and statutory charge of both the county appraiser and the Board of Tax Appeals to appraise real estate at fair market value. Functional obsolescence compares the existing improvement with the highest and best use of the property. There's a highest and best use analysis of the highest and best use of the property as it exists, and the highest and best use of the property as vacant. And functional obsolescence is measured by comparing the existing improvement by the highest and best use of the property as vacant. So the hypothetical employed by the Board of Tax Appeals in Kansas Star in this instance is that the highest and best use as vacant would be a casino with the smallest possible physical footprint. The fewest, no more bells and whistles than necessary to maximize the income potential of the property or as a gaming casino. But it's undisputed that the highest and best use of the subject property, both as it exists in January 1, 2018, and as vacant, is to use the subject property as a gaming facility, one of the 4 statutorily authorized casinos in the state of Kansas, and this one being in the South Central Zone, consisting of Sumner and Sedgwick counties. So the analysis here in determining the hypothetical, which assumes the smallest possible footprint, is, and the flaw here is that a gaming enterprise or improvements that do not include the ancillary facilities, again, the arena, the conference center, and the equine facilities, is not legally permissible in Kansas. And then
Mr. Cooper, is that one of the main bone, or one of the main issues that the experts disagreed on here? Didn't Mr. Jackson disagree with that?
He did not disagree. He did not disagree. He in fact agreed. Both appraisers agreed that gaming on the facility in January 1, 2018 would not be permissible without the ancillary facilities. So
that it was legally required by the contract?
Correct.
Thank you.
And so again, in terms of as it exists, and Mr. Jackson agreed and testified that the ancillary facilities, one, exist. They're perfectly functional, meaning they're well built. They can perform the functions for which they were built. The arena, you can have a concert in there, you can have a rodeo in there, you can have monster trucks in there if that's your thing. The equine facilities are fine for holding horse shows, and the conference center is perfectly functional as a conference center. So then the deviation happens from, okay, it's there, you have to have it in order to game on the property, but for postulating the highest and best use as vacant, we're going to do a do-over. And we will postulate not this management contract or this management agreement, but we will postulate a different management agreement by which the facility operator will bid and build only the gaming floor and the restaurants necessary to actually run the casino itself, which is inconsistent with reality. And it's inconsistent with the history of this property, which is there's never been a management contract approved that in turn permits gaming on the subject property that does not include these ancillary facilities.
But that was the basis of BODA's finding, was it not, that the arena or the ancillary facilities are not required to get a management contract?
It's a species of that.
Okay.
It's not. I can't go all the way there, but most of the way there with you, Judge.
Okay.
What BODA said is that this is the existing management contract is not the only one, and you can have a management contract that doesn't include these, but that steps aside and starts to look and compare apples and oranges, because again, when you're the Hollywood Casino in Wyandotte County, Blue Hill Casino in Southwest Kansas and Dodge City, and the Kansas Crossings in Pittsburgh, they're different gaming zones, and statutory requirements to game there are different. Why? Because they have management agreements that permit what they built. And there is one and only one management agreement for the South Central Gaming Zone. And this couples with 79503 AJ, which when considering fair market value, you're required to consider restrictions imposed on the real estate by the government. And BODA views this as just a personal contractual obligation And we don't dispute the idea that this contract's not transferable. The statute itself and the contract itself says it is not property. It is not real property. And that's fine as far as it goes. But the hypothetical, again, baked into the hypothetical is that the hypothetical buyer is going to buy this property and continue to game on it to get access to the outsized profits that are available from the monopoly market created by the Kansas Expanded Lottery Act in the South Central Gaming Zone. So the buyer, baked into this is the ability to continue gaming. And there's one and only one way to game on anywhere in the South Central Gaming Zone. And that is to have the ancillary facilities required by the management contract. And so when we're again, this hoists us right back to where I started, when we're positing the hypothetical to build to the highest and best use as vacant, it has to be a legally permissible use. And if it's not a legally permissible use, it's to be discarded in doing the highest and best use analysis. And in our brief, we discussed along the example of, at least as the law exists today, we could make a whole lot of money in Kansas by building and operating a marijuana dispensary, but doing so would not be legal. And the argument that was posited by Kansas Star and adopted by BOTA is that Kansas Star could make the same amount of money with less infrastructure investment in fewer physical facilities. In other words, the ancillary facilities don't add substantially to the bottom line. We disagree with that. And we discussed that evidence in the brief, but that's not the focus of the argument here. It's they posit, well, we could make the same money with fewer facilities, so we're going to posit a management contract that doesn't require those things. And we're going to assume that we can get that management contract, and with that management contract, we can game on the property. And that's where this falls off the rails. You don't get to fundamentally change the rules in developing your hypothetical as is. It has to be a legally permissible use. And it's, again, all of these hypotheticals and the analysis assumes that the buyer will operate a lawful gaming facility in Kansas. And there's only one way to do that.
Mr. Cooper?
Yes.
What about the 2015 case by the Court of Appeals with the same client? Didn't it essentially approve the same depreciation analysis that BOTA applied here?
Short answer is yes. One, it's not binding precedent, and year over year, tax appeals are not, 1 year is not binding over the next. That's also an unpublished decision, so it's not precedential, and it's certainly not binding on this panel. And we still contend it just gets it wrong. It allows an analysis that goes all the way through by assuming a use that is not legal. And it focuses on the fact that the management contract in and of itself is not real estate. We don't disagree with that, but it is a government restriction on the use of land, and their highest and best use assumes a use that of gaming. And there's only one way that can happen. The legal permissibility for gaming in the South Central Gaming Zone is fixed. That contract was let in 2010, and there cannot be another one. So when they're positing a different gaming contract, a different management contract, that's a second management contract, and you can't do that.
You have about 2 minutes before your rebuttal time.
I appreciate it. So we can't, essentially, they're presuming a do-over, and if we're going to do that do-over under the Expanded Lottery Act, that goes all the way back to allowing a new vote in Sedgwick County. And again, how far you can't, when you're rewinding the clock, you have to take it as they exist in January 2018, January 1, 2018. This is the way that you can game in that gaming zone. And that's the only way you can game in that gaming zone. And again, Kansas Star's appraiser, Mr. Jackson, agreed the management contract exists, agreed these facilities are required, and agrees that if they were destroyed now, they'd have to be built back, or Kansas Star couldn't get the money. So when we're addressing fair market value, we cannot assume a different management contract than the one that actually exists. I've already said there's nothing wrong with these facilities. They fulfill their design. So we loop back to the statutory definition of fair market value. What would a willing seller, well-informed seller take from a well-informed buyer? And there is zero evidence that the willing seller in this hypothetical would ever take anything less than 100 cents on the dollar for the real estate assets that are part of the gaming facility. And everybody agrees that in this hypothetical transaction, the going concern is what would be transferred. I'll reserve my remaining time for rebuttal.
Thank you, Mr. Cooper. Mr. Kiefer, you may proceed. Mr. Kiefer, I think you're muted.
You are absolutely correct. Thank you.
Thank you.
You hit on with one of your questions, Judge Gardner, already what's going to be the highlight of what I have to say here today, and that is essentially the 2015 decision in the same matter that was decided in May after the briefing was completed. Mr. Cooper said the short answer to your question was yes, that these questions were already answered by a different panel of this court, and that's true. In fact, it's more true than what Mr. Cooper is letting on. The facts between 2015 and 2018 are essentially materially identical. Same experts on both sides, same methodologies, same appraisal experts, same methodologies being used, same central issues, same arguments briefed by the parties, exact same arguments were made there as were made here. And in fact, when BOTA issued its 2015 decision, and you have to kind of understand the procedural history, 2015 was remanded from the Court of Appeals to BOTA, and BOTA re-decided that case. But so from a timing perspective, but when BOTA issued its 2018 decision, this decision, it cited the 2015 decision, which was at that time the most recent decision in this case, and was material identical, and said, basically quoted a page and a half of the 2015 decision, said our analysis is the same here in 2018 as it was in 2015, and for the same reasons. So BOTA was saying these cases are so similar, we don't have to rewrite this analysis. We're going to copy and paste it and quote it, a page and a half of it from our old decision. These are literally the same case. It is a different tax year, but the underlying and material facts are absolutely the same. The briefed issues are exactly the same. And what the county is now asking is for this panel to overturn the judgment decision of the prior panel.
Well, we often disagree with our prior panels. We don't necessarily overturn them, but if we would publish a case disagreeing, it may not have that effect. But why isn't that 2015 case wrong? Why isn't it the fact that you have to look at that existing management contract that they're locked into in determining what the highest and best use would be of that property?
Absolutely. I want to answer that two ways. One, with reference to the 2015 decision and why it decided what it did. And second, in response to what Mr. Cooper said here today. So with respect to what Mr. Cooper said here today, there are two key elements of what is required to run a casino in Kansas. One of those is you have to meet the minimum requirements of the Kansas Expanded Lottery Act. And those minimum requirements actually only requires you to operate a casino itself. There's actually a distinction in the statute between a lottery gaming facility, which is just a casino, and a lottery gaming enterprise, which is a casino with additional amenities. The lottery can approve either one, But as a practical matter, I agree with the county on this. You do have to have additional amenities. They're not going to let you put up a Morton building and game out of it. I completely agree that's not a realistic result. That being said, a lottery gaming enterprise with ancillary amenities, those amenities can include, according to the statute 748702A, can include restaurants, hotels, museums, and entertainment facilities. Here, we have many ancillary amenities at the Kansas Star Casino. There's the casino floor itself. There's a steakhouse, a high-end steakhouse. There's the Tin Lizard live music venue and bar. It's a kind of a bar setup with a small stage for a live music setup. There's a buffet, a large buffet. There's a quick service restaurant and cafe. There's multiple bars throughout the facility, and there's a 300-room hotel, a fairly large hotel attached to the facility. Those are the amenities. When Mr. Cooper says the board and Mr. Jackson found all the amenities to be completely obsolete and all we want to do is put up a butler barn, that's not correct. Every amenity that I just listed is an amenity of the facility that was not deemed to be 100% obsolete. In fact, other than the hotel, which is a separate tax parcel, all those amenities were deemed to be 100% good, 0% obsolete. The only amenity at issue here is the arena with its associated equestrian event center. That amenity, the experts determined and BOTA agreed, was 100% obsolete because it was a money-losing operation that, when it was built, was expected to drive not necessarily its own revenue, but drive visitation to the casino, which would increase overall profits. And you can see from our brief where we cite that the original projection said that use of this arena and construction of this arena would increase tourist visitation, tourist gaming spend, and would ultimately increase profitability from 13 million in 2012 to 43 million in 2016 when full build out was achieved. In reality, the profitability of the facility dropped by 13.5 million or 14 million between those 2 years. So clearly that didn't happen. Instead, the arenas were actually a drag, and Mr. Morowitz goes through all his analysis, which probably isn't necessary for us to go into here, about how having those people on property with the entertainment venue crowded out the lucrative gamers, and they were at best casual gamers, and there was no correlation between events and increased gaming revenue. And if anything, it was decreased gaming revenue as a result of events. So we know that. Now, looking at the hypothetical sale, there's a hypothetical sale that has to occur here. And that hypothetical sale is on January 1 of 2018, we're assuming that there's a sale of this real estate, just the real estate, from Kansas Star Casino to some other entity. And we assume that that's a fee simple sale that is unencumbered by any private agreements. And that's really where the county's argument falls apart. We're certainly not assuming that this is going to sell and be something other than a casino. We agree a casino is the highest and best use. That being said, the contract between the state of Kansas and the Kansas Star Casino to operate this facility is a private agreement between those two. It is by statute not property, not transferable, not alienable, and does not run with the land. So it's not as though when Kansas Star sells this facility on January 1, 2018, that the next owner automatically gets this agreement. There would be—
But counsel, historically, yes. Isn't that what happened?
No, nothing like that has ever happened. This casino has not sold. Boyd Gaming acquired Peninsula Gaming in 2012, but that was one parent company acquiring another parent company. Because Kansas Star Casino LLC is a subsidiary of Peninsula Gaming, there was no change of ownership in the management contract. It just continued to reside with Kansas Star LLC because that's an entity that pre-existed the transaction and existed after the transaction.
Did the state have to approve that anything to do with that transaction?
Regulators have to approve the new people in charge of the entity. KRGC, Kansas Racing Gaming Commission, the civil enforcement agency, has to sort of background check the new people in charge to confirm that they meet KRGC standards. But nothing changed in terms of the management agreement itself. It remained identical and with Kansas Star Casino. So that transaction really didn't bring into play how that would occur. But also—
Mr. Keeper?
Yes.
I'm sorry. Go ahead and finish your thought. I thought you were done.
No, that was it, I think.
My question is, what about Mr. Cooper's argument that under 79503A, I think it's J, that you do have to consider government restrictions in doing fair market value of land assessment.
Right. As we have argued in our brief, which predated the 2015 decision, but then was adopted in the 2015 Court of Appeals decision, the key phrase in 79503A is that it restricts, sorry, let me pull up the exact language, 503A. It requires that fair market value, that it has kind of a list of considerations to be considered in fair market value. And one of those is restrictions or requirements imposed upon the use of real estate. Two reasons that the 2015 court rejected that, same reasons we've argued here and have always argued. One, it is not imposed on anyone. It's a private agreement that Kansas Star Casino agreed with in the state. So that's not an imposition the way, say, a regulation is an imposition on the real estate. And secondly, it's not an agreement upon the real estate. That is, this is not an agreement that runs with the land. In fact, quite the contrary, it cannot run with the land. When the land is sold, it would literally kill this agreement. If Kansas Star Casino would then be in violation of the agreement because it cannot maintain and operate this casino because it sold the underlying land. So that there is no second contract or different contract. The fact of the matter is, if this property sells in any kind of sale, hypothetical or otherwise, there has to be a new agreement entered into. Either the new purchaser says, we'll work with the Kansas Lottery to adopt the same agreement, the management contract's already in place, or we're going to negotiate a new one. Under either of those two scenarios, I can establish by clear fact that the arena does not get paid for as part of the transaction. It does not generate any additional compensation. If we assume that the new purchaser purchases the property with the existing management contract, that is, negotiates with Kansas Lottery and says, we'd like to adopt this management contract, so let's enter into the identical management contract here, and Kansas Lottery says, okay, that's fine. If that happens, this property will sell, and everybody agrees it will sell as a multiple of EBITDA, which is a profitability margin used in the industry. And so let's just, to use simple numbers, I think I have this hypothetical in my brief. If it were generating $100 million of EBITDA and it were sold at a 7.0 multiple, then 7 times 100 million is 700 million. You would buy the entire enterprise, that is the going concern, the contracts in place, the right to game, the personal property, the real estate. You get the whole going concern for $700 million. The question then would be, what you'd have to extrapolate that down to figure out what the real estate component of that is. But if we sold the same facility, but without the arena, let's say the next purchaser says, I'm going to keep the same management agreement. I'm going to negotiate with Kansas Lottery, and Kansas Lottery lets me keep that management agreement, but I don't really want the arena. I see that it doesn't make any money. It doesn't do me any good. So I'm going to leave that part with Kansas Star Casino and with the obligation they continue to operate in compliance with the contract. And I'm just going to buy the casino itself. Assuming the casino itself can generate $100 million of EBITDA, which in fact, it would probably generate more EBITDA than that, I'll still pay $700 million and I don't get the arena. So I will pay the same amount of money for the enterprise, whether I get the arena or not. In fact, I'll probably pay more for the enterprise if I don't have to take the arena. That is proof positive that even under the existing management contract, that arena is not worth anything. It's not contributing to the value of the property. Now, if we assume that I can change the management contract, that I will change it to what is, I will negotiate with the Kansas Lottery to have a new management contract that does not require me to operate the arena. Again, I would still pay the same amount of money for the overall facility, but I would either close down or repurpose or do something different with the arena under some different management contract, whatever that might be. And now this all ties into what Mr. Cooper actually alluded to, which is very astute. There are two types of highest and best use. Highest and best use as improved and highest and best use as vacant. They're trying to commingle the two. The county's trying to commingle the two into one. Highest and best use as improved, everybody agrees, is to continue to use the property as it is. You already have the arena, you already have a management contract in place, you would continue to use it as it is. That's the highest and best use. However, when we're determining what to compare the facility to, its ideal improvement, so that we can determine the difference, which is depreciation, that's the difference between what we have and what we would ideally have, that is a comparison with the highest and best use as vacant. That assumes that we have a greenfield project, grass and nothing else, and then we have the opportunity to do this over. The highest and best use conclusion of Mr. Cooper's expert, Mr. Jortberg, was that you'd build the exact same thing and go get the exact same management contract, or be bound by the same management contract, which doesn't make sense because this is an as vacant analysis where we assume we're starting over. Mr. Jackson's highest and best use as vacant says you're going to build the facility that is maximally productive under the current standards, under the current facts and circumstances as of January 1, 2018. And that would be essentially everything that is there except the arena. And that's the conclusion.
So Mr. Jackson was proceeding on the basis that the management contract was not legally required. I mean, when you're considering the ideal or the as vacant, I mean, he's sort of assuming either a new management contract or you can change management contract.
No, what we have to separate here is the highest and best use as improved, that is, as it sits today with all the factors in place, versus as vacant. He says if this were vacant and it were a greenfield project, you'd build the project that is maximally productive and meets the requirements of the Kansas Expanded Lottery Act, which is sort of self-evident, but that would not include an arena. That's a different analysis because the only reason you do an as vacant analysis is to create the ideal improvement to which you are comparing the actual improvement. And the 2015 court actually addressed the same issue and said the exact same thing. You don't have to assume that there's a difference between the management contract, that is the personal agreement between the Kansas Star Casino and the state, and a management contract, which complies with the Kansas Expanded Lottery Act. As the 2021 panel said, the 2015 panel said, the county's position is that you must consider the management contract that exists today between Kansas Star Casino and the state, rather than you may consider its influence or the influence of a management contract on the facility. And that is essentially the assumption of the taxpayers' experts, is that yes, you have to have a management contract, but when we're evaluating this as vacant, there is absolutely no reason, if you have a greenfield project, that you would assume in 2018, when you know a lot more than when this was built in 2012, and certainly than when it was bid on in 2010, that you would necessarily build the same project. It would make no sense if you had a greenfield project and no obligation, because this management contract is a personal agreement. It does not transfer with the land. It is not connected to the land. If I have a greenfield project, as a matter of fact, I have to go and get a management contract to build and operate a casino. And we're certainly assuming that there is a management contract, that someone would go and negotiate and bid or whatever the necessary steps were to get a management contract. And it was an extraordinary assumption, Mr. Jackson, that such an agreement would be reached. Otherwise, if you assume there is no management contract in place, the value would be land value, essentially. Nobody would pay a lot extra for the hope that you might go get a management contract. And that's really the difference. We're not assuming that there is no management contract. That is not true. What we're saying is the private agreement Kansas Star has with the state of Kansas is not part of the real estate. And this is not a novel, and it's not some extreme position. It's literally written into the law. The management contract by law is not property, is not alienable, does not transfer with the land. Kansas Star could not go out on January 1st, 2018 and sell this property and say, here it is, ready to go, here's your management contract. It literally cannot do that. The subsequent purchaser would have to go to Kansas Lottery and either negotiate a new contract or negotiate to accept the existing management contract. And as the hypothetical I gave you earlier notes, that is not, in either case, the next purchaser will not give any value for the arena. Just as a matter of mathematical fact, no one is going to pay $1 extra because the arena exists. The arena doesn't generate revenue, doesn't drive gaming revenue as they expected that it would back in 2010 when they did the bidding on this project. And in fact, that's the reason this arena and Equine Event Center was going to be much bigger. They were going to do more horse stalls, more buildings, a bigger outdoor arena. And they ended up, after realizing how poor this performed in phase 1B, for phase 2, they went to the state and said, we need to renegotiate this. We do not want to do a further expansion of the Equine Event Center. How about we build some ballrooms instead? And that's what they ended up doing with the money that they would have expanded the Equine Event Center with. And that just goes to show that the state lottery would certainly be willing to discuss with someone what works best for this facility and not say, no, you're going to have to do the thing you said you were going to do back in 2010, because back in 2010, you thought that was the best thing to do. And
Counsel, Council, on that issue, I understand the county's position to be that your argument with respect to the arena being obsolete is contrived, that maybe the Star hasn't tried hard enough to actually utilize the arena. And so just because you haven't marketed it, you've created this situation artificially. Can you speak to that argument?
Sure, that's just not true. That was a statement, an unsupported statement made by the county, and maybe Mr. Jortberg made that suggestion in actual testimony, but no one with actual knowledge of how the property was marketed and is used said that. In fact, Mr. Schroeder testified that in fact they have held equine events, they have held level 1 and level 2 equine events, and that they have tried to market the facility for larger events. They've marketed as 4-wall events where they would let someone come in and control the entire event, soup to nuts. They tried to market it where they would run the event. Kansas Star would provide the staff to actually run the event, and he said they had no luck attracting those events, and the events they did attract did not meet the pre-opening projections for how well they would do, either in terms of the revenue that they generate or in terms of the gaming revenue that they would generate for the casino by additional visitation. Neither of those metrics were met for the events they did hold, level 1 and level 2 events, and they never were able to attract anyone to hold any level 3 events. So it's just not true. There's no evidence in the record whatsoever by anyone with personal knowledge that they did not try to market this for these activities. They did, and it just did not work out.
Mr. Kiefer, I'll give you a couple minutes to sum up.
Sure. So I think I've really covered all of the high points, but the reality is that the county is trying to pigeonhole this case into one thing. The one thing that they have to make their argument is that Kansas Star's management contract, its personal agreement with the state that does not run with the land, is not property, is not transferable, is not alienable, cannot be encumbered, that private agreement between Kansas Star and the state is a land use restriction that must be considered as part of the fee simple estate. And that fundamentally is just not true. The fact of the matter is the next purchaser would have to negotiate for a management contract on its own, and would not be entitled to the management contract, let alone would it run with the land as a matter of right. And that is really where the county's argument falls apart. And in the 2015 decision from May of this year, there's really 6 key facts that the court points out there that are critical here. One, the management contract is a personal contract between Kansas Star and the state and not a land use restriction. That's a finding of the 2015 panel. Secondly, the personal contractual obligations are not part of the fee simple estate. Third, the management contract may influence the value of the property, but that's different than it must be part of the property. Fourth, the fact that the management contract can influence does not mean that there is no functional obsolescence. Even with the influence of a management contract, you can have functional obsolescence. Finally, while KELA, the Kansas Expanded Lottery Act, the law itself, is a land use restriction, and the existing facility is in compliance, it's well beyond the minimum requirements, has far more amenities than are necessary, and compared it to the Hollywood Casino that is basically this casino we have without the arena, without the event center, and without the hotel. And that was found to be, of course, perfectly acceptable because it exists today and has a management contract. And finally, that the calculation of super adequacy is a factual issue. The county would like you to believe that's a legal issue, and it's not. Legal issues are things like Kansas requires fee simple interest valuation. The actual calculation and estimation of the presence or absence of super adequacy is a factual issue that was found by BOTA to be existing and calculated, and I think that should be upheld.
Thank you, Mr. Kiefer.
I just want to
Oh,
add
another
one
question.
quickly. Mr. Kiefer, you mentioned a gentleman by the name of Mr. Schroeder as a witness in this case. And since we're being recorded, I just want the record to reflect that I don't know that individual. And since our names are the same and that we're not relatives in any way that I know, just so that there's no confusion.
Great. I actually think he was with Boyd Gaming in the past. I think he's worked in maybe Illinois and Las Vegas. So he's not even a native to Kansas or anywhere.
No problem. I just thought that with all the issues that I ought to make that clear for the record.
Appreciate that. Thank you, Judge, and thank you, Mr. Kiefer. Mr. Cooper, you have 5 minutes rebuttal. And Mr. Cooper, I think you're muted.
And trying to make my mouse work at the same time. Okay. All right. Thank you, Judge. I appreciate it. Taking the closing comments of Mr. Kiefer first from the 2015 appeal. Again, those 6 factors that Mr. Kiefer read to you and that are in Judge Powell's decision, those are a micro view of the management contract, and it's an examination of why the management contract in and of itself is not property. I started by stipulating that. We spot you that one, but that's not the issue we're tasked. Our task under the statute is to determine the fair market value, what a well-informed and willing seller would accept from a well-informed and willing buyer. And both experts in this case said that in this circumstance, the only way that transaction occurs is if the going concern, the Kansas Star itself, transfers, which Judge Klein, you noted, that actually happened here, which is the parent company, Peninsula, was acquired by Boyd, and the regulatory aspects of that had to be approved. It would be so both appraisers and BOTA assumed, all right, that will happen. The regulatory rigmarole that will allow the transfer from the current owner to a new buyer will occur. But what else is baked into that? And Mr. Jackson starts by saying, again, in the highest and best use as vacant, we view this as a greenfield project. Well, a greenfield project is not the same thing as starting over under Keela. Keela was set in 2015 when the management contract was let. There's one, only one, and there cannot be another in that zone. So that, and that's what Mr. Jortberg testified to, and Mr. Sellers, who's one of the other experts that testified to, is you cannot, in a USPAP compliant appraisal, change the rules of the road that way by changing what is the fundamental underlying pin of, which is the ability to game in Sumner County anywhere. Because again, if this is way too much history, but we have to go back to 2007 when the Expanded Lottery Act was passed. There had to be local elections approving gaming. Sedgwick County rejected gaming at that time, which made the properties in Sumner County viable at that point in time. And there were 3 rounds of bidding, and in that process, all of that happened. And we cannot posit a do-over of that entire process, because now you're no longer dealing with the subject property. So again, we're not saying the contract itself is property, but the contract fixes the ability to game, and the ability to game is baked into everybody's hypothetical sale. So if the buyer wants to game, they're going to have to take the management contract as is. And as Mr. Jortberg and Mr. Sellers testified, well, then because those are required, the highest and best use as vacant is to build what is required to game on the property. And that is a facility with the arena and ancillary facilities. And that's where I started, which is in arriving at this, Mr. Jackson and BOTA have fundamentally changed the hypothetical, which is selling this property to a willing seller or a willing buyer. Everybody agrees that it'll transfer as a going concern, and the EBITDA calculation that Mr. Kiefer discussed in his brief, that's nothing but the income approach to valuation. And the last step of the income approach to valuation is to determine what percentage of that income approach is attributable to the real property, which forces us back to the cost approach, which is where we are and what we're talking about. Whether it's a $700 million enterprise, a $620 million enterprise, the sticks and bricks are the same. and they cost the same to put into place. And that's why we're doing this by the cost approach. And so the assumption that you would have to go get a new management contract ignores the statutory mandate to take the property as it existed on January 1, 2018, and determine the amount of money that the willing buyer and the willing seller would accept. And there is evidence in the record that the buyer will pay whatever the seller demands for the real property in order to gain access to the property. And there is zero evidence that the current landowner would take less than 100 cents on the dollar. And all of the evidence is when this hypothetical sale occurs, it occurs the way Mr. Kiefer suggested, which is an EBITDA multiplier. But at the end of the day, the real estate allocation is a real estate allocation, and that will be allocated 100 cents on the dollar to the real estate. So I think I've gone my 5 minutes. Absent further questions from the panel, I very much appreciate your attention this morning.
Thank you.
Council, we appreciate the good arguments, and we will take the case under advisement and get a written decision to you when we can.